Hi, good morning, everyone. I hope you can hear me okay now that I've been unmuted. Thank you to Future South for inviting me to speak on the Environment Bill today. It's not an easy task. I mean, it's a very live issue. The bill is at the moment, I've set a timeline there for you, and we'll talk about that. But just to give you the latest news, which is that the bill is going through a parliamentary committee stage. At the moment, tomorrow is its last sitting, and then it will go to the House of Commons, expected to be passed in a day, the third reading, and then it will go to the House of Lords, where I think a lot of the new amendments will be subject to greater scrutiny. So why do we have an environment bill? Well, I think the main driver to have such a mammoth 236 page of bill is leaving the EU. Now we are leaving the EU, and the consequences of that are varied. One of them is that all EU law, UK environmental law, about 80%, that's the figure that's given at the moment, 80% of it is EU derived. And so we had to ensure that the day we leave the EU, we need to keep as UK law all that body of law. So there was something in 2018 called the EU Withdrawal Act, and that created the concept of EU retained law in the UK. So all the existing body of case law, legislation, regulations, statutory guidance, etc., on the day we leave, on the 1st of January 2021, well, we've left, but we're in the transition period. So 1st of January 2021, all that law will be part of the UK statute book. There were other issues, and the EU Withdrawal Act required the government to come forward with a bill to address these issues within 6 months. In that bill, the government was to create a policy statement on environmental principles. And the reason we needed that is because there's a whole body of environmental principles under EU law and the EU treaties, which are not part of UK law. So we wanted to incorporate that. And also there's a huge governance gap. We will lose the Commission as a supranational supervisory authority of the government in terms of whether they're implementing environmental law correctly. As you know, the Commission would have powers to infract the government and also to bring it to the Court of Justice of the European Union. So massive governance gap. We've taken a layer off, and this bill required that the government establish an independent authority which would have power to take legal proceedings against the government for failure to comply with environmental law. So a bit of the Commission's role in the UK, and I'll talk about that body, and that's going to be the Office for Environmental Protection. The bill has been plagued by delays. It was introduced in the Queen's speech in October 2000. I want to get sorry, I just need to pass my screen. Yeah, there we are. In 2019, and we're now in November 2020, and it's going through committee stage. We don't expect, and the Secretary of State for Environment has said this, we don't expect the bill to receive royal assent until probably Easter next year. So that's the background, but for me, the bill goes further. Actually, we have the 25-year plan. We've had a waste strategy. We've had a resource efficiency strategy, or water strategy. We had the plastic crisis, etc. So this bill is bringing together those EU gaps, so cover that, but also it does some innovative things such as conservation covenants, which I'll talk about later, but it also addresses some of the waste law, which had grown a bit haphazardly in England and needed to be brought together in one body. So it does that as well. That's the content of the bill, and that's courtesy of IEMA. And you will see that in the middle, we have environmental governance. So the monitoring, the review of environmental law and enforcement. And then around it, those are all the contents of the bill. It deals with air quality, with waste, with resource efficiency, water, nature, and biodiversity. One of the first clauses of this bill, sections of this bill, are environmental targets. So the government is under an obligation to set long-term targets, long-term binding targets for air quality, natural resources, waste and resource efficiency, and water quality. And those are going to be the things against which we're going to measure the improvement or not of environmental law in this country moving forward. In August, DEFRA published a paper on how they were going to set these targets. There's not much flesh on the bone there, really. We will know, and these targets need to be in place by 31st of October 2022. The next thing the Environment Bill does is it creates environmental improvement plans. And this is really the detail. How will the government improve the environment? How will they achieve those long-term targets? You know, we're talking about sort of 15 years minimum of activity to achieve those long-term 15-year targets and shorter interim targets. The environmental improvement plan has to be reviewed every 5 years, and the Secretary of State will have to report to Parliament on progress. When the bill becomes an act, the 25-year environment plan will be the first environmental improvement plan for England. The issue here, and I guess this is a bit of commentary, the National Office for Statistics and the Natural Capital Committee have been critical of the government in terms of following up on the 25-year plan. There's big statements there, such as leaving the environment in a better state than it was for future generations. But we haven't got, I don't think, a proper plan yet. So there's a lot of work for the government to do in this, and establishing targets will be part of this work on environmental improvement plans. Environmental principles, again, as I said, you know, whole body of EU principles that will disappear because they're not in sort of legislation. And although sustainable development isn't one of the principles, the Secretary of State has a duty to prepare a statement of environmental principles. And the objective of that is to contribute not only to environmental protection, but also to sustainable development. So a wider remit. This statement on environmental principles, which we haven't seen yet, and we won't see for a while, is the thing that the government will have to use when they create policies on environmental protection. So they'll have to use this as a sort of a standard. So when they're making laws, rules, regulations, they'll say, does this fit in with the statement on environmental principles? The main principles is that environmental protection should be integrated into the making of policies, the principle of preventative action to stop environmental damage, the precautionary principle, the polluter pays principle, and rectifying environmental damage at source. And I think those that have been working in the environment sphere understand those quite well, but let's see how they play out in the statements of environmental principles. The bill also creates a very heavy workload for the Secretary of State, who has a number of duties. The Secretary of State will have to monitor progress through achieving these targets in the priority areas of waste, air quality, water, biodiversity, resource efficiency. It will have to determine and report to Parliament on whether the environment is actually improving. It will have to prepare this policy statement on environmental principle, and now also report on significant developments of international environmental law. That last bit was something that came in the October bill that was missing. This is a newish amendment that came in when the bill went to Parliament in October, and everyone was quite concerned about the government being able to lower environmental standards, particularly when it comes to a trade agreement or trade agreements with other countries. And people lobbied very strongly, including UKLA. We wanted a non-retroactive clause in the bill. We didn't get that. What we got is a clause that says that any minister that's making changes that affect environmental law, and those changes are made in a bill, and where those changes reduce environmental protection, they will have to explain to Parliament why they are doing that. So they can do it, they just have to explain to Parliament. Also, let's remember that most environmental law is driven by regulations. We don't get many environment bills. So my view is that we still have to work on that clause when it goes to the House of Lords. The watchdog, as it's called, or the super regulator, as I like to call it, is the OEP. As I said, this is to cover the governance gap left by leaving the EU. That OEP has an objective, and its objective is to contribute to environmental protection and environmental improvements. It has three different, very broad functions. It monitors, it reports, and it has enforcement functions. So in terms of what does it monitor? Well, the main thing is the implementation of the environmental improvement plans and whether we are meeting the standards set in the priority areas, both the long-term targets, 15 years, and the interim targets. It will also look at whether the government's implementing environmental law properly. There's just been an amendment that has gone through to exclude climate change law again. Now, the reason why this amendment was put forward, I am told, is to make sure that the Committee on Climate Change and their functions don't overlap with those of the OEP. UKLA and myself personally thinks this is a mistake. There's enough in the bill about a memorandum of understanding between the two bodies that would cover that. And I think it's quite dangerous to exclude things like emissions trading from review of the OEP, aircraft emissions, marine emissions, and a few other things. So watch that space, because I think that's going to be an important thing moving forward. The OEP will report to Parliament yearly on the above, and it may recommend how progress could be improved. The Secretary of State can also, there's no duty, but can also request advice from the OEP on when there are changes to environmental law. So advice and monitoring function. Let me backtrack a little bit and to say that the functions of the OEP in terms of enforcement are to report on failures by public authorities who either are not taking environmental law into account properly when exercising their functions, or they're failing to exercise their functions properly. So the OEP is going to regulate public authorities. Now, there's just been a clarification put through in the bill where, you know, it's clear that includes those public authorities include government ministers, national regulators, and local authorities. the OEP will only look for serious breaches. It's not, you know, it's not going to be any small breach of environmental law, a badly issued permit, for example. It's not going to be that. It has to be a serious failure. And I think qualities of serious there would be that it's recurrent, that it's national, and that it has a high degree of harm or high probability of harm. The way that the Office for Environmental Protection is going to carry out its enforcement functions against public authorities is it can initiate investigations on its own, and it can act on complaints received from the public. There's an amendment going through in the bill at the moment that says that public authorities will also be able to complain against public authorities. That was left out before. It's been suggested. We wait and see how that amendment will play out. But at the moment, it can initiate investigations itself, or it can act on complaints received from the public. And that is, you know, that is a really good thing, because not many people would go to the Commission and complain, although they could, but they're more likely to go to the OEP and complain. And there's going to be a whole complaints procedure. The OEP is going to have a strategy and an enforcement policy. So all of that will be set out, and those are the standards against which complaints are going to be sifted as to whether they're accepted or not. The OEP has escalating enforcement powers, and it's anything from notifying the complainant to issuing an information notice. And the information notice is when the OEP has reasonable grounds to suspect that there's a serious failure. The OEP will have to describe that failure, and the information notice would be requesting information to investigate the allegation. If the OEP is not happy with that, it can serve a decision notice, and that decision notice it will be served when, on the balance of probabilities, the OEP is satisfied that the authority has failed to comply with environmental law. If that doesn't work, then there are two avenues. If the serious breach of environmental law is has a quality of urgency, then the OEP can bring proceedings in the High Courts for judicial review. And if it's not so urgent, after the 6 weeks pass for bringing judicial review proceedings, the OEP could bring an environmental review again in the High Court. This is a change. So the previous, the latest amendments to the bill are to take away from the upper tribunal the power to carry out environmental review. So everything in the High Court. And the reason the government gave for this is that they were concerned about inconsistencies of courts. So they want everything in the High Court. One could argue as well that if it went to the upper tribunal would carry out a different sort of investigation, because the upper tribunal, in the upper tribunal, experts can sit. So query why that has happened. My view is that I don't mind if it's in the High Court. Perhaps it's a mixed opportunity to create more flexible proceedings, but I do understand the reasons, and I think they've differentiated quite clearly when you need a judicial review and when you need an environmental review. In terms of the remedies, many wanted the OEP to be able, the court to be able to issue fines against the government, as the Court of Justice of the European Union does, but that didn't go ahead. It's basically the same remedies as judicial review, but no damages. Here, let's remember, the key is the seriousness of the breach of environmental law by a public authority, and it has to be something that's of national importance. And I'm happy to speculate on what I think would be maybe one of the first areas that the OEP would look into. But I want to make it clear that this body is not set up as a very aggressive body. This body, there's enough in the bill that the OEP will be continually discussing with government, discussing with public authorities. I think that we won't get to these enforcement functions unless the matter is very, very serious and unless the public authority is not collaborating. I'd like to add that in the bill, public authorities have a duty to cooperate with the OEP. Sorry, one more thing on the OEP. The OEP to investigate a breach of environmental law by a public authority, the first sifting requirement is that the person complaining has to have used up all the internal complaints, appeal, etc. procedure of the public authority it's complaining against. So the person has to exhaust all internal complaints and review procedure in the public authority before it goes to the OEP. I only wanted to talk for half an hour. It's a really big bill, so it's please bear with me. At the moment, we know that the bill will receive royal assent before the 31st of December 2020. So the Secretary of State is setting up an interim secretariat. They're recruiting a chair designate, and we think that the appointment will go to committee in December. And they're also going to start recruiting a CEO designate. That interim secretariat will take complaints, will carry out some monitoring functions, but will not have enforcement functions because it doesn't have the statutory power. It's a stopgap measure. In terms of waste and resource efficiency and being a jobbing waste lawyer, this is the thing that excites me most of the Environment Bill. Really, you know, there's the charge on single-use plastic, the power to create deposit schemes, but household waste collection is going to change. Food waste needs to be collected once a week, and we're going to have real separation of recyclable waste streams. And this is all to assist the circular economy and to ensure that we can really recycle the waste that we collect. Very exciting that we're going to introduce electronic waste tracking. That is, I think, a pivotal instrument to stop waste crime. You know, we're going to be tracking electronic waste, and that will just shore up all the producer responsibilities that manufacturers or importers, exporters have. There's going to be a ban on exports of plastic to non-OECD countries and other hazardous waste. That already exists, but it's added in the bill, which is great. Producers are going to have to fully pay for the disposal of their waste, including packaging waste. That's something new, although, for example, there's these packaging waste schemes that producers join, and there is a contribution. Still, the local authorities were paying for this, so that it's all, the cost is going to be passed back to the producer. And there's going to be a real market drive for resource efficiency standards and labeling of products to drive a shift in the market, to create a more circular economy and to give the consumer choice as to which products it wants to buy and whether they're meeting their standards or not. There could be enforcement action. Air quality, I'm not going to say very much about air quality, just that it seems to all have landed on the door of local authorities now. There are provisions on smoke control areas. There will be civil sanctions now instead of criminal sanctions. The local authorities will have power to address solid fuel burning on inland waterway vessels and smoke control areas. And there's going to be strengthening of the offences of selling certain solid fuels and appliances in smoke control areas. the big one here is that the government will create a regulation to allow a recall of vehicles from manufacturers that do not meet environmental standards. And I think that will be extended to other goods. In terms of water management, the thing that I want to raise here, and I think I had a client years ago who had a permanent abstraction license. From 2028, the Environment Agency will be able to revoke this type of license without liability for compensation. So I think, from my point of view, if I have any clients with permanent abstraction licenses, I try to be doing something about it now. And another thing, and I've got nitrates there in brackets, is that the Secretary of State will be able to change the standards of chemical substances that go into water and the chemical status of surface water or groundwater. And this slightly rings alarm bells when I think of the nitrates issues we're having down here in the Solent, and whether the government is going to take action to reduce protection here. They say the government has always said that they're not going to reduce environmental protection, but I think we need to carry a watching brief on this. In terms of nature and biodiversity, all developers are going to have to provide a minimum 10% biodiversity net gain as a condition of their planning consent for new development. There's going to be a register of BNGs, and there's going to be a market in this. So again, government applying market mechanisms to achieving net zero carbon. A recent amendment I'm quite excited about as well is that UK businesses are going to have to carry out due diligence on their supply chain when it comes to buying products that have been grown or derived from areas that have been deforested illegally. And that includes a lot of products, you know, chocolate, soya, palm oil, rubber, timber, pulp, and paper. There's going to be a ban on buying those products from areas which have been deforested illegally. So that's really quite exciting as well. Conservation covenants, the environment, I know the laws, I've been working on this since 2009 when I responded to a Law Society consultation on conservation covenants. And this is, I think, quite a good thing that the government is doing. They're going to allow voluntary but legally binding contracts between landowners and responsible bodies, and that includes public authorities and charities, to conserve natural heritage or features of land. So for example, if a local authority makes a commitment to plant 1,000 trees, they may use a conservation covenant with a landowner to bind that land for a period of time. It could be in perpetuity. It depends on the title that the landowner has on the land as well, but it will be a local land charge. So it really does have effect. The parties can modify it or discharge it by agreement. Otherwise, it could end up in the upper tribunal. And I think that's it from me. I want to thank Richard Hall and Erin Leahy for organizing, our chair, Ben Earl, and the Future South Board, and members and all attendees today. I know it was a whistle-stop tour of the Environment Bill, but I wanted to give you a framework so you understand the main touch points.